Hello guys, once again, I'm Prakash Lahiri, and we are here for the fifth lecture that I'll be giving on, that is the processing of property. I have divided this, and we'll be starting it now. This is the first part, so let's get going. What is passing or transfer of property? Transfer of property in goods from the seller to the buyer is the main object of a contract of sale. Property in goods means the ownership of goods, that is the good that has been owned by the person who is going to transfer. An article may belong to A, although it may not be in his possession. B may be in possession of that article, although he is not its owner. So let's say we have a watch. Now for the watch which is you've given to your friend, now the watch is not in your possession, but it is your watch, so you're the owner. You have the owner. You're the owner of the, but you're not having the possession of the watch. Similarly, B, your friend who has the watch right now, he is in possession of the watch, but he's not the owner. It is important to know the precise moment of time at which the property in good passes from the seller to the buyer. The passing of property implies transfer of ownership and not the physical possession of goods. For example, when a principal sends goods to his agents, he merely transfers the physical possession and not the ownership of the goods. Here, the principal is still the owner of the goods but is not having the possession of goods, and the agent is having possession of goods but is not the owner. Now, what does it mean? It basically means the effervescence. The fact is that, again, as we spoke about the watch concept, the watch story, it's similar to that. You are the principal who is the owner of the good, but you're not in possession. It is transferred to the agent who is in possession of the goods but not the owner. Now, what is the significance of transfer of property? The time of transfer of ownership of goods decides various rights and liabilities of the seller and the buyer. Thus, it becomes very important to know the exact time of transfer of ownership of goods from seller to buyer to answer the following questions. Consequences of transfer of property. This is an important topic. What is going to happen when there's a transfer of property? So the risk prima facie transfers from the seller to the buyer. That is, you sell a good and the possession goes from the seller to the buyer. Now the risk, whatever that is related to the commodity, that might be it is brittle in nature, that it might break quite easily, or let's say it has a possibility of getting rusted, or it's a perishable good, so in time period it might just have an expiry date. The risk is on the buyer now, not on the seller. The buyer acquires proprietary rights over the goods. As it is a fact, seller may sue for the price of property in case the buyer has not paid. Yes, so of course, in a case when they have not paid up the money, you can always be sued if there's a transfer is made, but there's been no payment made. When the seller is a company, the buyer gets a good title against the liquidator in respect of the goods which are in possession of the company. When a seller is a company, the buyer gets a good title against the liquidator in respect of the goods which are in possession of the company. It's a very clear statement. Next, property passes when intended to pass. What does section 19 say? Section 19 says property passes when intended to pass, which means where there is a contract for the sale of specific or ascertained goods, the property in them is transferred to the buyer at such time as the parties to the contract intended to be transferred. Which means that there's a contract for the sale of a specific or certain goods, the property in them is transferred to the buyer at such time as the parties intended the contract to be transferred. The timing. For the purpose of ascertaining the intention of the parties, regard shall be had to the terms of the contract, the conduct of the parties, and the circumstances of the case. The intention, what has been there for the transfer of the mere sale, or merely it has for other purposes. So there are various ways. This is all mentioned in section 19 of the Transfer Property Act. Next, a landmark case, Sagar Warehousing Corporation versus Pawan Helicopters in the year AII 2009. In a contract of sale for specific ascertain goods, the property was to pass to the buyer only upon the payment of the sale of consideration. This is half of sum of 4,50,000 was paid out of the 9 lakh. It was held that the property in goods was not passed to the buyer and therefore continued to vest in the seller. Unless you make the complete payment, till then you are not the owner of the property. Moving on, in the Chidambarm Chettiar versus Steel Bros. This is a landmark case, again in 1946. The contract of sale of paddy provided that the paddy in the first instance would be delivered to the defendant for the storage, and the plaintiff would have an option to name a day on which the defendant would purchase at the rate prevailing for that date. Now, it is a ratio decidendi case. It was held that it was clear from the terms of the contract that the property in goods would not pass until the plaintiff had not exercised the option. So if the plaintiff had not exercised, then the contract would not pass in this case. Another is this Ames versus Jull. It was held that the contract was for the sale of a motor car. As per the terms of the contract, the payment of price was to be made in monthly installments, and in case of default, the seller would be entitled to get the car back and would not have to refund the money already received. It was held that it was the intention of the parties that the property in the car would not pass to the buyer until he had paid the full price. Now, what are the rules relating to the passing of property? For the purpose of ascertaining the time at which the ownership is transferred from the seller to the buyer, the goods have been classified into the following three categories. First, specific or ascertain goods. Those are the type of goods that mean which goods have identified and agreed upon at the time when a contract of sale is made. That is, let's say for a television that has been brought from some store. Then unascertain goods that have not been seen upon, goods sent on approval or on a sale on return basis. Now, what are the sale of specific goods in a deliverable state? Now, specific goods in a deliverable state states that under section 20, that where there is an unconditional contract for the sale of specific goods in a deliverable state, the property in the goods passes to the buyer when the contract is made. And it is immaterial whether the time of payment, the price, or the time of delivery of the goods, or both, is postponed. Next, in this case, as observed by Sir Creswell in Gilmer versus Suffolk, in a contract of sale, the property immediately vests in the buyer and a right to price in the seller, unless it can be shown that was such not the intention of the parties. This statement was further approved by Lord Blackburn in Calcutta Company versus De Motors. There were three essentials that were listed. First, that the contract must be unconditional, the contract must be for the sale of specific goods, the goods must be in a deliverable state. Now, in the case of Dwarkadas versus Ramratan, it was in a contract of sale of specific goods in deliverable state. The buyer requested the seller to postpone the delivery for some time. It was held that the property passed at the time of making the contract, and the postponement of the time of delivery of goods was immaterial. The second most important element of section 20 is that the goods must be specific. What are the specific goods can be seen by the way of example in the case. In KIRSELL versus operators and contractors, the contractor was for the sale of uncut timber consisting of all trunks and branches of trees, but not seedling or young trees of less than 6 inches in the diameter at the height of the 4 feet from the ground. The timber was also to be cut by the buyers within a period of 15 years. The judgment was held that the property in goods did not pass at the time of the contract was made because the timber was not in a deliverable state. This was held according to section 20. The specific goods put into deliverable state. Section 21. It states that where there is a contract for the sale of specific goods and the seller is bound to do something to the goods for the purpose of putting them into deliverable state, the property does not pass until such thing is done and the buyer has notice thereof. This was again held in a similar case that was held in Gilmer versus Suffolk by Justice Blackburn. Now, Lachmi Niwas Rice Mills versus Firm Ramdas and Ramnivas. There was an agreement to sell rice by the appellants to the respondents. Under the agreement, the appellants were required to put the rice in bags and book it on a railway, dispatch it when the wagons became available, and finally deliver the railway receipts to the respondents. The appellants could not dispatch the bags according to the contract as wagons were not available for a reasonable time. The judgment held that since the property in the rice did not pass on to the respondents, the appellants could not sue as they failed to find the wagons that put the bags of rice ready for the dispatch in the deliverable state. Now, specific goods in a deliverable state when the seller has to do anything thereto in order to certain price. Under section 22, it is held where there is a contract for the sale of specific goods in a deliverable state, but the seller is bound to weigh, measure, test, or do something other act or thing with reference to the goods for the purpose of ascertaining the price, the property does not pass until the act of such thing is done and the buyer has notice thereof. Now, in Summons versus Swift, the case was the contract was for the sale of a bark at a certain price per ton. The agents of the seller and buyers were required to get the bark weight to ascertain the price. Part of the bark was weighed and taken away, but before the remaining bark could be weighed, it was carried away by flood. The dispute was regarding whether the buyer or the seller would be responsible for the loss. It was held the seller would bear the loss when goods are unascertain. Again, section 18. When goods have to be ascertained, where there is a contract for the sale of unascertained goods, no property in the goods is transferred to the buyer unless and until the goods are ascertained. Illustration: where there's a contract for the sale of trees, the property in the trees cannot pass until the trees are felled and ascertained. With this example. Now, who shall bear the risk? As we again revise, it is the owner who has to bear the risk, and not the person who merely has possession. Who can take action against the third party? It is the owner who can take action, and not the person who merely has the possession. Thirdly, whether a seller can sue for a price. The seller can sue for a price only if the ownership of goods has been transferred to the buyer. In fourth, in case of insolvency of a buyer, whether the official receiver or the assignee can take the possession of goods from seller. The official receiver or assignee can take the possession of goods from seller only if the ownership of goods has been transferred to the buyer. In case of insolvency of a seller, whether the receiver or assignee can take the possession of goods. The official receiver or assignee can take the possession of goods from the buyer only if the ownership of goods has not been transferred to the buyer. Thank you very much, guys. I hope you have a great time.